Hi, everybody. Today's Facts in 5 video is all about whether or not you can disinherit your spouse. Do you actually have to leave money to your spouse when you pass away? Unfortunately, the answer is it's complicated. So, what do I mean by that? In Connecticut, there's what's known as a statutory share. You can write a will that says, I intentionally leave no money to my spouse. But that's not necessarily the end of that question, because you cannot unilaterally decide to disinherit your spouse. Connecticut grants a spouse the right to a statutory share of your estate. So even if you say, I leave nothing to my spouse, your spouse still has a right to say, nope, I don't like that, and can choose to take a piece of your estate anyways and essentially override the terms of your will. So, what is the value of that statutory share? The statutory share is a life estate or a life use of 1/3 of your estate, your probate estate. So just to be clear, that's a 1/3 interest in only those assets that are actually passing under your will. So the statutory share is not going to apply to assets passing under a beneficiary designation or passing under a revocable trust or passing through joint ownership. Because all of those assets owned in trust, assets passing under a beneficiary designation, and assets passing through joint ownership all pass outside that whole probate process. So the statutory share is only going to grant the spouse a life use of 1/3 of the assets that are passing through probate. But that statutory share right is not automatic. Your surviving spouse has to proactively elect to take their statutory share. So if you leave your spouse $1 in the will, or you say you leave them nothing in the will for whatever reason, they can say, yep, that's okay, that's the plan, and leave it at that and choose not to take their statutory share. There's always that option. However, if they choose to override the terms of your will, again, they can, but they have to be proactive. They have to actually file that election saying, yes, I'm electing to take my statutory share. They have to file that with the probate court. And that filing must be provided to the probate court within 150 days of the decree that formally admits your will to probate. So they have to elect to take that share, and they have to do it within 150 days from the date that probate is essentially opened and the will is submitted for probate. The statutory share is also going to become a potential complication when it comes to Medicaid eligibility. So to give you a hypothetical, husband and wife, husband is currently on Medicaid because let's say he's in a nursing home and needs substantial long-term care. So the wife says, I'm not going to leave husband a whole bunch of assets just because he's going to have to spend that money on his care. It's going to make him ineligible for Medicaid if he gets a whole bunch of money, which he's then just going to have to spend down. It all goes to the nursing home anyways. I want to avoid that result. So instead of wife creating a will that says, I leave nothing to my house, and essentially maybe she can't because the state is going to recognize and say the husband has this right to the statutory share to wife's estate. So husband has to, whether he likes it or not, exercise this election and elect to take his statutory share of wife's estate. And if he doesn't, that's going to be deemed that he had assets, he gave them away. So there may still be a penalty for Medicaid eligibility purposes. So husband or husband's personal representative, so like his power of attorney or conservator, may be forced to exercise that statutory share, even if he doesn't want to. So kind of to, again, avoid that result and still leave husband in a good place for Medicaid eligibility purposes. Instead of wife's just saying, I leave nothing to my husband, the wife can say in her will, I leave my husband his statutory share. I leave him a life interest in 1/3 of my probate estate. And maybe it's even held in a special needs trust, this type of trust that's set up to say, yes, these assets are going to husband, but going to him in such a way that it's not going to jeopardize his continued eligibility for Medicaid. So, and then when husband dies, the wife then gets to say, then those assets go to the kids or my nieces and nephews or wherever else those assets are supposed to really go. So again, it's still, we recognize that the spouse does have the statutory share, but avoids a situation in which leaving assets to the spouse or forcing the spouse to take his elective share or statutory share is going to cause issues for Medicaid eligibility purposes. So the short answer is, can you disinherit a spouse? Not really. Or if you can, again, there has to be some kind of complex planning where you're not entirely disinheriting the spouse. You have to at least leave them the amount of their elective share. And also too, as a planning tool, as I mentioned, The elective share, that statutory share, only applies to the probate estate. So a simple option two is also just to make sure there's not a whole lot of assets or any assets in your probate estate. Just make it sure everything is passing under a beneficiary designation or through a trust or through joint ownership, which is going to make sure those assets are not going to be subject to that statutory share. So as always, please feel free to take a look at the other videos on our YouTube channel where we have more information about probate and about Medicaid eligibility and things like that, or just visit our website, www.kkc-law.com, for more information about us or to contact us to schedule an appointment.